But first thing, we have some minutes to approve. Kathy previously sent out the minutes from January 12th, 13th, 14th, 19th, 20th, and 21st. My understanding is Representative Burris had a correction to the 14th. Kathy, if you're on there and you dare risk unmute yourself, I know you sent out the corrected ones, but is it something significant that we need the members to, or is it something you just point out that we could go ahead and approve them today?
Yeah, it was during this discussion on HB 2048, an amendment and some discussion that occurred, and I had referenced Representative Burris instead of Owens.
Okay.
So it was just a name change.
Perfect. So committee, Kathy, go ahead and mute yourself. There we go. Perfect. Committee, is there a motion to approve those minutes? Representative Hoheisel? Is there a second? Representative Humphreys? All in favor say aye. All opposed say no. Minutes are approved. Okay, we'll open the hearing on Senate Bill 122. Natalie, are you going to take a stab at this, or are we just going to turn it over to Dean Kincannon?
Whichever you would prefer, Mr. Chairman.
Well, I don't actually care. Well, Natalie, why don't you get started, and then we'll see where we end up.
Yeah, I think I can be kind of brief because I do know Professor Kincannon will go into the details. So Senate Bill 122 modifies certain rules of evidence in the Code of Civil Procedure related to the authentication of records and documents. Section 1 amends KSA 6460. It adds a provision that permits a custodian or other qualified witness to certify certain records and permits certification under 465, which is amended later in the bill. Section 2 amends 6464. Subsection A under the bill would apply to other items of evidence and provide that authentication requires a proponent to produce evidence sufficient to support a finding that the item is what the proponent claims it is. And then later in subsection B, a non-exclusive list of 10 examples of evidence that satisfies that requirement. You'll see that there. Section 3 amends KSA 6465. The bill adds a new subsection B, providing 10 other items of evidence that are self-authenticating and require no extrinsic evidence of authenticity in order to be admitted in court. Section 4 amends 6467. The bill adds recordings and photographs to the statute and clarifies the rule in subsection A that the original writing, recording, or photograph is required in order to prove its contents unless the rules of evidence or a statute provides otherwise. Subsection B there provides that a duplicate is admissible to the same extent as the original unless there's a genuine question raised about the original's authenticity or the circumstances make it unfair to admit a duplicate. A new subsection E provides for proving the content of a writing, record, or photograph by testimony, deposition, or written statement of the party against whom the evidence is offered without accounting for the original. New subsection F is similar to the current law there in subsection B, which clarifies the role of the judge and the jury regarding the content of a writing, record, or photograph. And then a new subsection H provides definitions to be used. And I can take any questions.
Questions for Natalie? Representative Carmichael.
I apologize for my tardiness, Mr. Chairman. Ms. Scott, it's been a long and tedious day, and I just can't remember whether we've even ever seen anything like this before. Could you help refresh my memory?
Mr. Chairman, Representative Carmichael, you would have thought with the extra time I would have properly done my homework, but I did not. Just 1 second here.
It's not like our revisers had anything else to do, Mr. Chairman.
Senate Bill 334 from last year is the bill you would be looking for.
Thank you. I appreciate your help. I'll look it up.
And Mr. Chairman, I would note that it looks like from the chat from our IT staff that the YouTube is down. I might just ask if the Harmony is still up.
I think that's a question for you, Marcus. Okay, looks like we're good. Okay, if there are no other questions for Natalie, we will move on to proponents, and we have one. Professor Kincannon's with us today to tell us all about this. Welcome back to the committee.
Thank you, Mr. Chairman, members of the committee. My name is Jim Concannon. I'm a professor emeritus at Washburn University School of Law, where I taught evidence in civil procedure. I'm appearing today on behalf of the Kansas Judicial Council, on whose Civil Code Advisory Committee I serve, and also the Ad Hoc Evidence Rules Advisory Committee that recommended this legislation. What Senate Bill 122 does is to conform the Kansas rules of evidence more closely with the federal rules of evidence on two topics. One that used to be called the best evidence rule, now called the original writings rule, and the second, the rules on authentication of evidence. Last year, Senate Bill 334 passed in the Senate, and those of you who were members of this committee last year heard very similar testimony before the pandemic forced things to shut down. The first 6 pages of the bill have only a minor conforming amendment to the hearsay rule. And so I really want to start with section 4 of the bill on page 10, because it addresses the problem with KSA 60-467 that prompted the Judicial Council to propose this bill. What we now call the original writings rule provides that when a party wants to prove a fact by proving what the words are that are in a writing, the party is required to produce the original writing itself, rather than other evidence of the words that are in the writing, the exception being when the party is able to show a satisfactory reason for not producing the original, such as that it was lost or destroyed without fraudulent intent. This evidence rule traces its origins back to the early 1700s in England, and the rule made perfect sense then. The only 2 available forms of other evidence to prove the words in a writing were quite inferior to the original as proof of what the writing said. It could be one oral testimony given from memory by a witness who previously read the document. The risk obviously is the witness may have misread the document or may no longer remember its terms accurately. The other form of proof might be a handwritten copy produced by someone who was looking at the original. The reliability accuracy problem there, of course, is that the transcriber might have been inattentive or careless and thus transcribed the original incorrectly. By the time the federal rules of evidence were adopted in 1975, of course, the Xerox machine and other reliable forms of duplication had been developed. And so while Federal Rule 1002 still excludes that oral testimony from memory from someone who read the document or that handwritten copy, unless a reason for non-production is shown. The federal rules added Rule 1003 to the federal rules, which is a rule that KSA 60-467B in this bill would add to the Kansas statute. And what it provides is that a duplicate is admissible to the same extent as the original, unless a genuine question is raised about the authenticity of the original or the circumstances make it unfair to admit the duplicate. And a duplicate is defined as a counterpart that's produced by a process or technique that accurately reproduces the original. And this provision has worked very smoothly in the federal courts since 1975. The Kansas rules of evidence were adopted in 1963, but they were, on this point, verbatim the uniform rules of evidence of 1953, when many modern methods of reproduction had not been invented yet. And so the Kansas Code doesn't contain a provision comparable to Federal Rule 1003, admitting reliable duplicates without requiring some other excuse. The Kansas rule thus can lead to the exclusion of reliable evidence, or at least increase the proponent's costs to track down the original and introduce it at trial. And the problem is illustrated by the Patrick case, which was a prosecution for DUI that's discussed on page 3 of our Judicial Council written testimony. In that case, the police department scanned the defendant's implied consent advisory form and stored a digital copy of it in its records. At trial, the defendant objected to introduction of the printout of the digitally stored form when the hard copy consent form wasn't produced. And our Court of Appeals acknowledged that Federal Rule 1003 would admit the printout as a reliable duplicate, but the court said our best evidence rule has not been updated for many years and does not consider scanned documents stored in a computer database to be the original document for evidentiary purposes. And Senate Bill 122 would fix that problem in new subsection B by adding the federal provision on duplicates. There now are 43 states that have patterned their state rules of evidence after the federal rules of evidence. And certainly some of those states have varied from the federal rules on some other issues, but there are virtually no variations from the federal rules regarding the original writings rule. And in fact, I believe only Maine among those 43 states omitted Rule 1003 when it adopted the federal rules. The federal rules actually use 8 rules to cover the topic of the original writings rules in Rules 1001 to 1008. Kansas covers all of that in just one statute, 60-467. And if you look at current subsection A, it covers so much stuff in a 35-line paragraph that it is nearly impossible to read. And so although we're not making many other substantive changes, what Senate Bill 122 does is to break 6467 into 8 subsections dealing with the different topics covered by the federal rules, and we reorganize the statute in order to improve readability. And in some places, what the bill does is substitute the text of the federal rule for the current Kansas text when the federal rule has the same effect and the drafting of that rule is clearer. I won't go through all those subsections unless you have questions. As Natalie mentioned, subsection E does add one new provision from the federal rules, allowing the content of a writing to be proved by the opposing party's admission in testimony, a deposition, or a written statement. Frankly, this doesn't come up much in federal courts, but our Evidence Advisory Committee concluded there was no reason not to conform to the federal rule on that topic. Given that the Judicial Council decided to recommend this change in 6467, it seemed an opportune time also to update and improve Kansas statutes relating to authentication, which is the requirement that before an item of evidence is introduced, the proponent must offer evidence that it is what the proponent claims it is. And Section 2 of this bill adopts, with one minor tweak, Federal Rule of Evidence 901 as a substitute for our current KSA 6464. And then the bill also adds in Section 3 a new subsection B to KSA 6465 that picks up provisions on self-authentication that are in Federal Rule 902 5 through 14. Current KSA 6464, to talk about Section 2 first, requires a party offering a writing into evidence to produce evidence besides the writing itself that is sufficient to permit the jury to find that the writing is authentic, that it's what it claims to be. This Kansas standard for authentication is identical to the standard in Federal Rule 901A, but the phrasing of the federal rule is better because it applies the same standard to all evidence for which authentication is required, not just a writing. The example would be evidence of a voice communication. That is not a writing. As Natalie said, Rule 901B then has a non-exclusive list of 10 examples that satisfy the authentication requirement. A Kansas court today could rely on any one of those 10 examples because they merely reflect case law decisions. And indeed, our Supreme Court in the Robinson case that's cited on page 3 of the written testimony relied on the example in Rule 901B4, even though it wasn't in the statute. But the consensus of the evidence committee was that having these examples in the statute will assist Kansas practitioners in planning for authentication and also make it easier through legal research to access federal decisions that apply these examples. The only variance in the bill is that Senate Bill 122 carries forward the Kansas 30-year-old requirement for an ancient document rather than the shorter 20-year requirement that the federal rule applies. Section 3 of the bill is the last major section. It expands the categories of items that are self-authenticating. In other words, that do not require extrinsic evidence beyond the item itself to authenticate it. An important point, self-authentication doesn't mean that the document is admissible. It can still be objected to as inadmissible hearsay or as irrelevant or inadmissible or under some other rule, or even because a distinct aspect of authentication must be shown that the self-authentication provision doesn't cover. For example, in the Patrick case that I mentioned, a certificate under new subsection B would be sufficient to authenticate that the implied consent form printed out of the computer reflects the item that was stored in the computer. But that implied consent form still wouldn't be admissible in evidence against the defendant unless the prosecution offered evidence sufficient to allow the jury to find that the signature on the form was in fact the signature of the defendant. And of course, nothing here could override a Sixth Amendment right of the criminal defendant to confront witnesses when it happens to apply to a particular document. Self-authentication, in other words, just means it isn't necessary to call a verifying witness for the aspect of authentication to which the rule applies, and the opposing party still can contest authentication before the jury. Under our current law in 6465, this applies only to public documents. Federal Rules 902, 1 through 4 cover the same ground, but the Senate Bill 122 retains the Kansas language on this, primarily because it's language Kansas lawyers are familiar with. But Federal Rule 902 includes additional categories of items that can be self-authenticated, and those are found in subsection B1 through 10 of section 3 of the bill. The first 6 of them were in the original federal rules. The last 4 have been added by subsequent amendments to the federal rule because of concern that without self-authentication, parties often were forced to incur substantial expense to call witnesses to authenticate a business record or an electronically generated bit of information when no challenge to authentication ultimately was made by the opposing party. I guess the point is all of these provisions were developed by the Federal Rules Advisory Committee to the United States Judicial Conference, were subject to public comment and hearing that sometimes led to revisions, ultimately approved by the U.S. Judicial Conference for submission to the Supreme Court, which sent them to Congress, which approved them. And I guess the summary is they've been thoroughly vetted. Although they aren't in the Kansas statute as of now, our Court of Appeals in the Crawford case effectively authorized self-authentication of acknowledged documents covered by subsection B4 in the bill by recognizing a presumption, and the certificate of a custodian that's used to admit business records produced in response to a KSA 60-245A third-party business records subpoena is the same type of certificate that is contemplated by subsections B7 and 8 of this bill. Again, I won't go through in detail all of these subdivisions in proposed 6467, or pardon me, 465B, but I think I will quit there and be happy to respond to any questions.
Thank you. Questions? Representative Carmichael?
Thank you, Mr. Chairman. Dean Concanon, I greatly appreciate you being here to help us today. And I also greatly appreciate the work of the Judicial Council, not only in connection with this, but many, many other statutes. Before I get to the substance of my question, I think you should know that I took civil procedure from Professor Eleanor Schrader, and I took evidence from Professor Emeritus Paul E. Wilson, and I took the evidence section of the bar prep course from yourself. And I think Gordon Self may have taken it at the same time or a month or two before or after. So understand my perspective. This matter of conformity, particularly of our evidence code with the federal rules, is one that has troubled me ever since law school, because Professor Wilson spent great time and effort making sure we knew the differences between the state evidence code and the federal evidence code. And then when I entered into practice and tried lawsuits, if you were on the east side of the street, you followed the federal evidence code. And if you were on the west side of the street, you followed the state evidence code. And it was something that caused trial lawyers to pull their hair out, and judges as well. So my question is broader than just this legislation. Is it perhaps time for us to think about conforming our evidence rules to those that are used in virtually every other court in the country, so that practitioners know what the rules are everywhere, and probably as importantly, so that our statutes keep up? Because some of this, as you indicated, had its origins back in 1963 and even before that. Is it something we ought to think about, perhaps just finally conforming our evidence code and making such tweaks as might be necessary, but try to do that on a limited basis?
Well, that's a broad-ranging question, and obviously this bill goes on at least two topics very much in the direction that you're talking about, where the policy issues don't differ very much. I can't help but saying, of course, I took evidence from Professor Wilson myself in the 1 o'clock hour after lunch back in the day. But it's a topic certainly that could be considered. I guess a place to start would be to say, because Kansas, when they started working on the federal rules, Kansas was only one of 4 states that had codified rules of evidence. We had adopted the uniform rules. New Jersey had, Utah had, and California has kind of a version of it. It had its own code that really wasn't the original uniform rules, but that means that the uniform rules, the Kansas rules, really were the starting point for the drafters of the federal rules. And if you read the advisory committee comments to the federal rules, they're constantly citing the Kansas statutes. But there are places where the federal rules went in a different direction as a matter of policy. And frankly, some of the places where they did was as a result of Congress making a decision about what evidence law ought to be that differed from the recommendations of the Federal Rules Advisory Committee that had tended to be more in line with the uniform rules and our law. So, you can, if we were to look at that, you could certainly identify a number of places where, in my view, as somebody who studied in the area, the Kansas provision is actually better than the federal rules. And the notion that there are differences between state rules and the federal rules is something that happens even in states that have, as a general proposition, patterned their rules after the federal rules. That every state has kept some of its former provisions, or tweaked here or tweaked there, and there has also gotten to be less uniformity in some areas, because although a state may have adopted the 1975 version of the federal rules, they didn't go back and pick up amendments to the federal rules that have been adopted over time. And so I'm constantly pointing out, when I was teaching evidence, not just differences between Kansas state law and federal law, but that even other states would have different provisions. I mean, certainly, with an infinite amount of time and an infinite amount of patience, going through and making a detailed study of where we think the federal rules are an improvement. Certainly in many places, the drafting of the federal rules, particularly after the 2011 restyling, is much better and clearer. And that could, we did that with the Code of Civil Procedure here in Kansas, something we could do with profitably with the evidence code. But the bottom line is, that would be a major undertaking.
And Dean, I certainly don't mean to suggest that today is the day to do that, but I genuinely appreciate your historical perspective, because, at least in my judgment, Mr. Chairman, it's something we ought to think about. I'm not saying we ought to do it. And one final remark, Mr. Chairman, for those who don't know, Professor Paul Wilson was the man who represented the state of Kansas in State versus Topeka Board of Education. And he wrote a wonderful book called A Time to Lose, and I commend it to everyone. It's a wonderful book about Kansas history, lawyering, and I commend it to you all. Thank you again for your help, Dean. Appreciate it.
Questions, committee? Not see anyone else here as a proponent? Anyone as a neutral conferee? Any opponents? Not seeing any. We'll close the hearing on Senate Bill 22. Thanks for joining us today. Now,
Thank
committee, let's get to work on some bills. We will start with Senate Bill 106. Natalie.
Thank you, Mr. Chairman. Senate Bill 106 enacts the Uniform Notary Act. It also repeals our old Uniform Act on notaries, and I can take any specific questions you have.
Questions, committee? Are there amendments? Representative Carmichael.
Thank you, Mr. Chairman. As I'm sure the committee will recall, Ron Smith journeyed from Larned to share with us his suggestion that we ought to make sure that we are not repealing by implication the unsigned declaration rule, or I think that's the phrase for it. And so what I have done is I've asked the revisor to prepare an amendment which would incorporate Mr. Smith's suggestion. And I'd like to have that distributed. Hopefully there'll be a second, and then perhaps address it on the merits.
I'm sorry, Mr. Chairman, I meant to remove all the extraneous pages, but when you do get that, the amendment appears on page 32.
And could I, with the chair's permission, if Ms. Scott could share with her the screen and point out specifically to, there we are, because it was a tedious day on the floor today and I don't have it immediately at hand. Mr. Chairman, I think it's fairly self-explanatory, so perhaps it might be appropriate to inquire if there's a second.
That's perfect. Is there a second? Representative Curtis seconds. Representative Carmichael, if you'd like to explain it further.
It is as I described before. Now, I think the committee should understand that I've been contacted by at least one person in this building who lobbies on behalf of the Land Title Association, who are good folks, and I don't mean to say otherwise, who expressed to me reservations. I couldn't quite articulate precisely what the nature of the reservation was. But here's the situation. As Mr. Smith explained to us, there are a few recorder of deeds offices, and perhaps even following some instructions that I haven't seen from their professional association, that suggest that unsworn declarations are somehow not acceptable in real estate transactions. As the testimony of Mr. Smith, I think, established, that that's just probably not at all correct. It's a matter of practice and old tradition and old ways that causes this impediment to filing these documents. And we need to make sure that we are not repealing by implication those provisions, and by, once again, restating that KSA 53601 is still good law in Kansas. We can avoid litigation about what our intentions were, and we can continue to use this method of authentication or notarization that has served us well for over 20 years now. And quite frankly, I don't know of an instance where there's ever been any serious problem that arose as a result of those unsworn declarations, which saved the parties a great deal of time, trouble, and expense. And I can explain that in greater detail should the committee desire. Thank you, Mr. Chair.
Thank you. Committee, any discussion on the amendment? Not seeing any. Has everyone had a chance to review it? Let's hit your email. Okay, I don't see anybody expressing an interest to discuss this in person nor online. So Representative Carmichael, you may close.
Mr. Chairman, I close and move my amendment. Thank you.
You've heard the motion. All in favor say aye.
Aye.
All opposed say no. I think the noes have it. Division's been called. All in favor, raise your hand, please. I see 4 voting in favor. Those voting against, raise your hand. 2, 3, 9, 10, 11 voting against. Motion fails. Well, I didn't hear that one well. Further amendments. If there are not any further amendments, then I would have one to change the effective date to publication in the Register. Seconded by Representative Hoheisel. Oh, maybe not.
I'll second it.
Okay, second by Representative Hoheisel. Discussion, Representative Hoheisel.
What's wrong with the publication date?
You know, again, there's something about it that it just didn't seem right. So I've decided to change it.
I'll support this motion.
Any discussion? Not, I will move my motion. All in favor say aye. All opposed say no. Motion carries. Back on the bill as amended. Any further amendments? Is there a motion concerning Senate Bill 106? Representative Hoheisel.
Thank you, Mr. Chair. I move we pass out SB 106 favorably as amended.
Is there a second? Representative Jennings. Further discussion? Seeing none, Representative Hoheisel, you may close.
I'll close.
Heard the motion. All in favor say aye.
Aye.
All opposed say no. The ayes have it. Those wanting their affirmative votes recorded: Owens, Hoheisel, Heiberger, Carmichael, O'Halverson. Now let's look at 2366.
Thank you, Mr. Chairman. House Bill 2366 deals with jailhouse witness testimony. It would require prosecutors to disclose their intent to use jailhouse witness testimony in a case, and then it would also put some reporting requirements on the use of that type of testimony. And I can take any questions.
Any questions for Natalie? Are there any amendments? Is there a motion on 2366? Representative Hoheisel.
Thank you, Mr. Chair. I move we pass out HB 2366 favorably.
Second by Representative Wheeler. Any discussion? Seeing none, Representative Hoheisel, you may close. Heard the motion. All in favor say aye. All opposed say no. Ayes have it. Those wanting their votes recorded in the affirmative: Owens, Hoheisel, Heiberger, Carmichael, O'Halverson. And Natalie raised her hand, so let's put Natalie down for that one too. Okay, committee, and let me explain this next one. I'm going to have Natalie, okay, so Senate Bill 60 is the one we're going to work. I would like to, we'll see what other amendments we have. The original porch piracy bill, 2229, I'll have Natalie explain that as well. This appears to be a good home to put that, and then we'll see how we get further down the road. But Senate Bill 204, which was the next bill on my list, if we're comfortable with it, I would potentially like to put all three of these together because, as I'll explain later in the meeting, we may have a bill or two coming through later this week, and it would be nice to have a Senate shell to put it in, and we're not going to have enough extra. So, Representative Hoheisel?
Can you repeat those?
Yes, so
3 total bills.
So the 3 total bills, which we'll have Natalie explain: 60, 204, and then 2229.
And those would go into 60.
Those would go into 60.
Okay. Thank
So
you.
let's start with Natalie explaining 60, and then we'll go from there.
Thank you, Mr. Chairman. Senate Bill 60 defines proximate result. For purposes of determining whether a crime was committed in the state, it would define it as any logical effect or consequence of such act, regardless of whether the statute governing the charged offense considers the specific effect or consequence of the act.
Any questions for Natalie on 60 by itself? Any amendments to 60? Don't see any. So now, Natalie, would you explain? Well, let's do 204 next.
Sure. Thank you, Mr. Chairman. Senate Bill 204 prohibits psychological exams for victims of criminal offenses.
Any questions for Natalie? Not seeing any. I'm going to make a motion to put the contents of Senate Bill 204 into Senate Bill 60. Is there a second by Representative Hoheisel? Any discussion? Representative Wheeler. According to Natalie, it is they're both criminal, and we have fairly criminals enough, according to the revisers. If it says criminal, they'll let us put anything together. It gets trickier when it doesn't say criminal. Representative Heiberger.
Thank you, Mr. Chair. Since I'm not sure I'm going to support Senate Bill 60, I'm going to oppose the motion.
Okay. Representative Carmichael.
Thank you, Mr. Chair. I am concerned about what we're doing here, and no disrespect to the chair, I'm concerned about the procedure that we are employing. These three bills are not at all non-controversial. And in fact, had I known that 2299 was going to once again rear its ugly head, I would have prepared an amendment today, an amendment which would provide, in cases of serial porch piracy, that the aggregate value of the stolen property must reach the felony amount, which I don't even remember because I wasn't prepared to argue this. So that's a reason that we shouldn't combine these bills. With respect to SB 60, I really call to the committee's attention the fact that this bill is in response to a case, pardon me, which is presently on review before the Kansas Supreme Court. In fact, the proponent of this bill was the loser in front of the Court of Appeals. And so now he appears in our committee as a court of last resort. This is way, way, way premature to even be considering or working this bill, let alone bundling it up with two other controversial bills. I would also remind the the committee, that with respect to Senate Bill 60, the Court of Appeals was probably on real good solid grounds in what they did. There was no crime committed in Kansas in that case. If there was a crime committed in Kansas, it's when the defendant made fraudulent representations to a State Farm special claims investigator in Wichita, Kansas. And for whatever reason, the lawyer responsible for this case at the Attorney General's office, different than the lawyer that we saw here, just failed in the proof, didn't prove the necessary element of the crime. And so what was proven, according to the Court of Appeals, was a crime was committed in Missouri, in the Kansas City area, and the effect, the proximate effect, was in St. Louis, or excuse me, was in Tennessee. And so this is a case of a prosecutorial screw-up. And it's brought to us by the lawyer who argued and lost the case, and who has now appealed it to the state Supreme Court. And if he's right, I have no doubt but what the state Supreme Court will fix the error. If we want our committee to have every case that the Attorney General loses show up here on our doorstep so that we can relitigate it, then we better get more staff, and we better expect to work every Friday, because there's a whole host of them. And so this is a bad precedent and a bad idea. Then we turn to the third bill in this evil package, and I don't even remember now. Oh, the psychological exam bill, SB 204, the Griffin rule, as I recall. It's been the subject of serious debate in this committee previously. Judges have the discretion in Kansas in very limited circumstances to order psychological evaluation of complaining witnesses. It's a very circumspect and a very tough test. I think the testimony of the Leavenworth County prosecutor on behalf of the County Attorneys Association was that he knew about one or two or maybe three. We had a significant example of that in the Wilson case that you may have read about over in Lawrence. Judge Portney has just granted a new trial. Judge Portney, as I understand the facts there, did allow a psychological evaluation of that complaining witness. Now, I may be somewhat wrong on that. So I have to oppose any attempt to combine these three bills into a devil's brew of bad legislation. They need to live or die on their own merits. And we're not going to be shortening anything up here, because if these bills go to the floor in a package, then they'll have to be dealt with one at a time, either by dividing the bills or by offering multiple amendments, and we can do on the floor the work that we can undo on the floor the work that we propose to do here today. So I don't think we should be amending these bills. They need to pass out of committee on their own merits, not as a package. Thank you, Mr. Chair.
Representative Geither.
Thank you, Mr. Chairman. I agree with the two representatives who spoke before me. I have serious problem going forward with Senate Bill 60. And I wrote down in my notes the issue regarding it being in the court and wanting to overturn an appellate court decision. So I'm struggling to put these in the same package. So I don't know if there's a different way to do this that we could go forward with, but I have some real serious heartburn with putting all these in one bill, especially the base bill being the one I really don't like. So thank you, Mr. Chair.
Further discussion? Seeing none, I will close and move my motion. All in favor say aye. All opposed say no.
No.
Motion carries. Okay, so we have 60 and 204 now combined into 60. 2229, I'll have Natalie explain it. And we'll see if anyone has a desire to add that. This appears to be one, if not the only option, to add that bill in if we want to get it out. It passed out of our committee before turnaround. It did not make it above the line. And so as I was looking at things that we wanted to try to save, I had that on my list, but we'll see what the committee wants to do. So Natalie, would you like to explain that, please?
Yes, thank you, Mr. Chairman. House Bill 2229 increases the criminal penalties for multiple thefts of mail. So when you have property that is mail of a value of less than $1,500, which is the current felony threshold, from 3 separate locations within a period of 72 hours as part of the same act or transaction, or in 2 more acts or transactions connected together, then that increases the penalty to a severity level 9 non-person felony. And then the bill also provides a definition of mail. And I can take any questions.
Okay, questions about what 2229 was? Representative Carmichael?
I'm sorry, I look forward to addressing it on the merits. I
Okay.
apologize.
Perfect. Does anyone have an interest in making that motion and putting it together? I don't feel strongly either way, but I wanted to make sure to bring it to all of your attention, so I'm not seeing anyone making a motion. Any further amendments to Senate Bill 60? If not, is there a motion concerning Senate Bill 60 as amended? Representative Owens.
I'll make the motion that we pass Senate Bill 60 out as amended favorably.
Is there a second? Representative Humphries, discussion? Seeing none? All in favor, Representative Owens.
I close.
Heard the motion, all in favor say aye. All opposed say no.
No.
Motion carries. Those wanting their affirmative votes recorded would be Owens, Hoheisel. Those wanting their negative votes recorded, Heiberger, Carmichael, O'Habasam. Now, Senate Bill 56.
Mr. Chairman, Senate Bill 56 would require the posting of certain human trafficking notices, and I can take any specific questions.
Any questions for Natalie? Any amendments? No one has an amendment, so I guess I'm still not comfortable with the effective date, so I'm going to make a motion that we change that to be the Kansas Register. Is there a second? Second by Representative Curtis on the amendment. Any discussion? Seeing none, all in favor say aye.
Aye.
All opposed say no. Now, back on Senate Bill 56 as amended. Is there a motion concerning that? Representative Curtis?
Thank you, Mr. Chair. I recommend that we pass out Senate Bill 56 favorable.
Good. Is there a second? Representative Hoheisel? Any discussion? Representative Curtis, you may close.
I close.
Heard the motion. All in favor say aye.
Aye.
All opposed say no. Motion carries. Got distracted thinking about the next bill. Those wanting their affirmative votes recorded. Owens, Hoheisel, Heiberger, Carmichael, O'Habisam. Now, Senate Bill 4. Natalie?
Thank you, Mr. Chairman. Senate Bill 4 changes the criminal penalties for the crime of tampering with electronic monitoring equipment. Right now, it's a 6. In the case of supervision related to a felony, the penalty would go to an 8. And in cases of supervision related to a misdemeanor or a civil case, the penalty for tampering would be a Class A non-person misdemeanor.
Any questions for Natalie? Amendments, Representative Jennings.
Thank you, Mr. Chairman. Natalie, can you distribute to everybody the amendment that we had in the Committee on Corrections and Juvenile Justice on this particular bill? I should probably let Representative Wheeler describe the amendment. I'm sure he remembers what his amendment was. So Natalie, you've got it up there. You want to go ahead and just describe this quickly, what it does, please?
Sure. Thank you, Mr. Chairman. As the bill exists now, any felony would be that higher level. This would take some misdemeanors and also make it a severity level 8 non-person felony instead of falling under the misdemeanor rule in paragraph 2. So you'll see there we have interference with parental custody, criminal restraint, domestic battery, stalking, intimidation of a witness or victim, and violation of a protective order. So those violation of, if you were on supervision for one of those misdemeanor violations and you tampered with your electronic monitoring equipment, then that would result in a severity level 8 non-person felony.
And that extended to violation of protective orders that were issued as well, right?
Yes, yeah, violation of a protection order is a misdemeanor included in there.
So that's the motion.
Okay, is there a second? Representative Wheeler? Discussion? Representative Humphreys?
Thank you, Mr. Chairman. Could we have just a little background?
Sure. This bill comes to us initially from the Kansas Sentencing Commission, has for a couple of years to align the penalties for tampering with electronic monitoring equipment, ankle bracelets, cutting them off, that sort of thing, in a way that this offense became less serious than it was, because escaping custody was actually a lesser severity felony offense than cutting off the ankle bracelet. So it was a question of proportionality. The amendment comes in as a result of conversations about the character of certain offenses that have historically demonstrated to, at a higher degree, have the potential of really bad outcomes when people cut these things off and they go around someone that they shouldn't be around. Kind of the character of the violation is what we thought in committee too. So we passed this out of committee as amended right now. It did not come above the line.
Any further discussion? Representative Wheeler?
Thank you, Mr. Chair. I think Representative from Lakin explained it very well, but from past experience in the prosecution field, the ones that we have drawn in the exceptions those are the highest risk of recidivism and returning to the victim to commit acts of violence. So that's why we request that we accept those and make them a higher level felony. And thank you, Mr. Chair.
Any further discussion on the amendment? Representative Jennings, you may close.
I close, move my amendment.
Heard the motion. All in favor say aye. All opposed say no. Now back to Representative Jennings to turn this into we're going to save everything from House Corrections bill.
This is exactly what's about to happen. So, as you know, we actually passed a number of bills, not only out of the House Committee on Corrections and Juvenile Justice, but a good number of those also crossed the House floor, and certainly are out there. But this is a way to go ahead and maybe raise the level of concern with our friends across the rotunda about the value of these particular bills. So what I'm going to do, Mr. Chairman, with your permission, is make one motion. And I think then if members wish to divide the question, that's fine. But I will tell you, to each and every one of these bills that I will talk about in this motion, each and every one of you have already voted in favor of it as it crossed the floor, because the votes on each one of these were 124-0. So there's not been any opposition. There's not been any controversy in the House whatsoever about these. It is simply a method to go ahead and put into a Senate bill something that might help get this work done this session. So the first bill of the motion to amend would be to include the contents of House Bill 2128. This relates to, and that was as amended out of the committee. It was not amended, as I recall, on the floor. Clarified jurisdiction for supervision of offenders in certified drug abuse treatment programs, and allowing non-drug offenders to participate. That last part, that's the short title. The last part was amended out. This is only about the transfer of supervision of defendants who are on Senate Bill 123, drug abuse treatment programming, to allow for the transfer of their supervision from one judicial district to another with the consent of all the parties, judges in both districts as well as the accused. And you may recall the conversation went something like, oddly enough, people from Kansas City go to Wichita, they get caught with drugs, they can get convicted. And in order to supervise and have them participate in the program, it's much more convenient for everyone concerned to do that in Johnson County or Wyandotte County, wherever it is they happen to live. That would be the first one. Do you want me to stop and answer questions as we go along, or just do them all?
Let's do questions here. Any questions? And we can do questions after we hear all of them as well, but let's take it piece by piece. So I don't see any. So move on to your next one, please.
Mr.
Next
Chairman,
one.
I would just note that I went ahead and sent copies of all the bills that are going to be talked about right now to Kathy. So I think she should be distributing them if you guys do want to review those.
Very good. Thank you, Natalie.
And Natalie, if I inadvertently, inaccurately describe a bill, let me know. I think I caught myself on the last one pretty good, so.
Always.
Okay, yeah, I could feel it. I knew you were thinking. Okay, so the second bill would be included in this amendment would be House Bill 2192. That relates to allowing court service officers and community corrections officers to provide a certification of identification to offenders to use to obtain a new driver's license. Again, this passed the House without amendment 124-0. And this was the business of community corrections and probation being able to verify identifications so that offenders who otherwise don't have the documents that the average person might be expected to have to provide proof of identification can use documents provided by those folks who have been involved with them, who have photographed them and fingerprinted them and verified their identity to provide a means to obtain a new driver's license for offenders when they're in this kind of a jam. That's that one, Mr. Chairman.
Okay, and it looks like Representative Carmichael has a question as to this one.
Yes, Mr. Chair, I have a serious question. My telephone rang as the distinguished chair announced what bill it was. Could you refresh my memory, Representative Jennings? What bill is this again that you're adding?
That'd be 2192, 2192.
Well, that's fine, bill. Thank you.
Okay, I don't see any other questions, so continue on.
Next bill would be 2128. Whoops, that's not right. Uh-oh. Now I've done it.
I wonder if you're thinking of 2191.
Yeah, I hope so, and I hope you can describe it because I evidently cut and pasted the wrong one 3 times. I'll go back to my other document here and find it. Maybe we'll just add a whole lot of bills in here. Yeah, that's what happened. Yeah, this is tedious, isn't it? This would be the definition, Representative Carmichael, if you ever wanted to know. The other one was 2191?
Yes.
Okay, 2191 would be the bill that increased the penalties for the crime of riot and incitement to riot when the crime occurs in a correctional facility. This one actually passed 123-0. There were no amendments in the committee or on the floor. It enhanced the penalty for riot and incitement of riot in correctional facilities to felony offense rather than a misdemeanor offense.
Any questions on this one? Finish with your last one, I think.
I think I have one more, don't I, Natalie?
I believe you do, yes.
2374, maybe?
2374. Right? This would be the bill that passed 124-0 that authorizes the Kansas Sentencing Commission to change the risk assessment cutoff levels for participation in their drug abuse programs. The commission has adjusted the instrument. They've changed the tool that they use for assessments, and the cutoff scores that were previously set no longer would apply until validated. They have to be able to adjust that. And this is what determines who's able to participate in those programs or not. It would be nice probably in the future, we sure can't do it this late this year, to just give them administrative authority going forward to make such a change. But for now, they need this bill in order to use their new tools to more effectively assess offenders. And there was a particular notation that they have a more appropriate assessment for females so that they don't get this bias that they experience in their present assessments. So those would be the bills that I would offer to amend into Senate Bill 4.
Okay, so let's have a motion to do so. Representative Jennings, second by Representative Owens. Any discussion? Representative Burris.
Thank you, Mr. Chairman. I was just wondering if we could just confirm the numbers of each of the bills that are being offered,
Yes, so we have 2191, 2192, 2128, and 2374 into Senate Bill 4.
Thanks.
Huh?
And I do just want to clarify that on 2128, it's the version as amended by House Committee. The rest of them have not been amended.
And the amendment by House Committee is the form in which the bill passed the House with 124 votes.
And just to give you all an update, it appears as though one of the four has not even been set for hearing on the other side. One is set for today maybe, and then the other two are set for Friday. So the odds of them getting them out of committee before Friday across the floor next week are quite slim. So any further discussion, Representative Heiberger?
Well, I would normally oppose this sort of thing, but given the fact that these are all non-controversial and pass with such high margins and they are all important, I will support the motion.
Seeing any other discussion, Representative Jennings, you may close.
Thank you, Mr. Chairman. I would just say, folks, this sets the stage for the potential coup of all coups, that Chairman Patton may, if this bill ends up going across the floor and becomes a part of a much larger conference committee report, could well take on the notoriety of having a conference committee report with the single largest number of individual bills contained within it. With that, I close.
And now you just lost Representative Heiberger's vote. Gosh. Okay, you've heard the motion. All in favor say aye. All opposed say no. Motion carries. Any further amendments to Senate Bill 4? If not, it's the desire of Senate Bill 4 as heavily amended. Representative Hoheisel.
Thank you, Mr. Chair. I move we pass out Senate Bill 4 favorably as amended.
Second by Representative Neely. Any further discussion? Representative Hoheisel, you may close.
Thank you, Mr. Chair. I close.
For the motion, all in favor say aye.
Aye.
All opposed say no. Motion carries. Affirmative votes, Owens, Hoheisel, Carmichael, and O'Habisam. Oh, I'm sorry, Neely and Heiberger. God, how'd I miss Heiberger over there? Okay, I had 3 more on my list, but we're gonna try one, which may take us a little while, but we'll see how it goes. Senate Bill 172. Natalie.
Thank you, Mr. Chairman. Senate Bill 172 would change the crimes related to critical infrastructure facilities. Right now, there is a crime of tampering with a pipeline. This would remove that crime, create 4 new crimes in its place. Trespassing on a critical infrastructure facility, aggravated trespass, criminal damage to a critical infrastructure facility, and then aggravated criminal damage. It would also define what a criminal or a critical infrastructure facility is. And then it would make the conforming amendments in RICO, as well as make the violation of that crime fall under the special restitution rule when calculating the total loss. And I can take any questions.
Any questions for Natalie? Okay, amendments, Representative Schreiber.
Thank you, Mr. Chairman. Natalie, does Kathy have that already to send out?
Not yet, but she will in just a second.
Okay.
Street corner. Yeah.
Did we get it? There it is. Okay. People received it.
Okay,
have it?
I've got it. Yep, everybody else have it?
Let me walk through it.
Yes, please.
This changes several different pieces of the bill. We'll start on page 1, where they strike, and this has been mentioned during the hearing, is to strike the word deface or defacing in lines 31, 35, and then also on page 2 on line 2. Then on page 3, the word any is substituted for a, and then just to kind of make the terms more consistently used throughout statutes. A facility generating electrical power is now electric generating generation facility. And electric power lines, including lines used for transmission of electricity, are now distribution or transmission lines, electric distribution or transmission lines. Then on line 14 on page 3, or video services added right after telecommunications, because that particular service was not incorporated or would not necessarily be incorporated within cable television at end, because on the telecommunication side, they aren't using cable. Then line 25 on page 3, after program, anti-terrorism standards program, says a facility operated by the Office of Laboratory Services under the supervision of the Secretary of Health and Environment, and so on and so forth. And then it also names the National Bio and Agro Defense Facility or the Biosecurity Research Institute at K-State. This was added to KDHE lab and INBAF and BRI deal with select biohazard agents, and this was brought to our attention both by KDHE and KHP. Then on line 26, it says dam that is regulated by the state or federal government. After talking with Earl Lewis with the Division of Water Resources, the state regulates dams, and they have 3 hazard classifications, A, B, and C. B and C are the higher classifications because if the dam breaches, then they could create damage to property and or structures and a possible life. C is the most hazardous in that it would have significant loss of property and or life. So that it would just include those 2. Class A dams might be, you know, a cattle pond in the middle of a pasture, and if it breached, it might have a little soil erosion, but it's not going to damage property. Then on line 27, after natural gas distribution utility facility, add or natural gas transmission facility. Here again, there are 2 different types of pipeline facilities. They're one distribution, which is to local customers, and transmission is between larger areas of the gas infrastructure. Then we go to page 5, lines 39 through 43. The italicized part is stricken, and this is, and if you have questions, it's probably best to ask Natalie for clarification, but by striking this would remove the application of RICO to these 4 new crimes, because we are amending 21-5818, and this would, the way the bill had been introduced, it included 21-5818 into the RICO statute. Now that is removed by striking this, those lines that I mentioned. And I believe, if I'm not mistaken, that is the last amendment. The piece that in section 3 is the restitution piece. That's all in the bold italicized part that was added over in the Senate. So if anyone has any questions, I'll try to answer them.
Let's move your motion.
I move my amendment.
Very good. Is there a second? Second by Representative Hoheisel. Before we get very far into the discussion, I'd just like to thank Representative Schreiber. We had a number of people raise concerns, a number of groups and agencies reach out to me in the last couple of days, and I'm like, see if Representative Schreiber will work with you and we can make it all work together. And he spent considerable time the last couple of days trying to get something that addresses the concerns that some of the concerns that we heard, and trying to come up with one balloon that would fix them all. So questions. First, we have Representative Carmichael, then Heiberger.
Thank you. Excuse me. Thank you, Mr. Chairman. I also want to extend my appreciation to Representative Schreiber for his good work here. As I'm sure you all know, I think this is a bad bill, but it I don't even want to say it makes it better, because then a member of the minority party would think it's a good idea and then it would fail. So I don't want to go that far. But my question, and it may be either for the representative or the revisor, is the significance of striking the word vandalism in, I believe, 4 different, vandalism or vandalize, in I think 4 different instances. What is the difference between defacement and vandalism?
That is an excellent question, Natalie.
Mr. Chairman, the first thing I would just note is we're actually leaving the word vandalize. So vandalize will still stay in there. The amendment just proposes to strike the word deface or defacing everywhere that appears. To really know the difference, I did do some looking in here. We do not have definitions of either one of these terms in statute. I will note that vandalize really isn't used as often as I might have thought. Defacing is used pretty frequently. But we don't have definitions in statute for what either of those mean.
And I apologize to the chair, Ms. Scott, and the committee. It's been a long, tedious day, and I knew that what we were talking about here, and I apologize for that. My concern is that if someone looks at the legislative history now and tries to figure out what we mean by vandalizing versus defacement, there's going to be an implication that we meant something by what we did here. I hope what we mean to do here is to not interfere with people's expression of their First Amendment rights. This is not, hopefully not an attempt to dissuade respectful, peaceful, civil disobedience, and still leaves open the standard charges relating to criminal damage to property and or vandalism, which would result in a lesser included offense instruction, so that juries will have a right to right the wrong that we're in the process of doing here today. Thank you.
Representative Heiberger.
Yeah, just for clarification, does this remove the changes in section 1 from the racketeering statute? I mean, does it remove section 1 from the racketeering statute?
I believe so, and Natalie can confirm, or Representative Wheeler can, because we've had this discussion, but
I preferred Natalie. Thank you very much.
Thank you, Mr. Chairman. So, and let me try to make clear. Currently, KSA 2158-18 is a crime. It's the crime of tampering with a pipeline. And under current law, that activity is included in the definition of racketeering activity in RICO. And that is why on page 5 here, you'll see that the KSA 2020 sub 2158-18, tampering with a pipeline, that's current law. That's not italicized because that's what it says right now. The way that the bill was introduced, it just updated that statutory reference because we're changing the names of the crimes, we're changing the elements of the crimes, so it updated that to reflect that. What this amendment would do is strike all of the activity under 2158-18 from RICO altogether. So none of this, none of these new crimes, the old crime we're getting rid of will be cleaned up. And so all references to the statute will be removed from RICO.
Representative Wheeler.
Thank you, Mr. Chair. Just very briefly, it was my recollection that the striking deface was moved earlier, and I thought that it was contemplated that that meant simply maybe graffiti as opposed to actual damage to the property. And perhaps I'm wrong on that, and I am somewhat concerned in that they are not defined anywhere in the statute. But it's my recollection that that was the intention, is that mere graffiti would not rise to the level of actual destruction of the property, which would come in line with the First Amendment, I might add.
Representative Jennings, then Hoheisel.
Well, I guess a couple of questions for maybe Natalie on this. So I tried to look it up real quick, but real quickly, I think my recollection is that criminal damage to property is causing damage to property through means other than fire or explosive falling into the crimes of arson, and it's damaging or substantially impairing the use. And I agree with you. The only place I could find vandalism was oddly enough with windshield insurance law. It seems like an odd place for it to show up. So it's not a defined term. I think the intent here is to try to make sure that we don't end up having kids who do something stupid on a big pipeline that goes over a creek and they spray paint it, that they end up getting hit with some massive terrorist kind of charge. And I'm worried about this because this language in here is not the same as what we see in criminal damage to property, but criminal damage to property does include, in fact, spray painting bridge abutments and doing other things, defacing property. So I'm not exactly sure how we get there. But the question for Natalie is, what about fire? If I damage a structure by means of fire.
Mr. Chairman, so neither the underlying, like our normal criminal damage to property statute, which if you guys want to look at that is 215813, that statute is knowingly damaging, destroying, defacing, or substantially impairing the use of any property. And so vandalize does not appear in criminal damage, but defacing does. Neither one specifically refer to fire. So, I mean, if it did fall under arson, then I'm sure that that would also be charged as well. But I'm sure that setting something on fire would also impair the use of that property, damage that property, potentially even destroy that property. So it's possible that either regular criminal damage to property, or if that property were a critical infrastructure facility, that one of these two crimes could be used in that scenario.
And refresh my recollection on this, Bill, what the damage to critical infrastructure is, what severity level?
Mr. Chairman, just the regular criminal damage you'll see here on page 2 at line 10 is a level 6. Aggravated criminal damage would be a 5.
And for arson against property that is not occupied is like a level 6 or 7, is it not?
Mr. Chairman, it looks like arson, which is KSA 215812. And looking at certain, depending on the circumstance in which you're committing arson, it ranges from a severity level 6. There's one that's a 7, and then aggravated arson is either a 3 or a 6.
And aggravated arson applies to a dwelling that is either occupied or there is someone injured as a result of the arson itself, as I recall. Is that pretty close?
It looks like aggravated arson would be arson committed upon a building or property in which there is a human being, or which results in great bodily harm or disfigurement to a firefighter or law enforcement officer in the course of fighting the fire. And then the difference in the severity levels are whether the risk to bodily harm happens or whether there's no substantial risk of bodily harm.
Representative Hoheisel. Oh, are you done, Representative Jennings?
Thank you, Natalie. Thank you.
Representative Hoheisel.
Thank you, Mr. Chair. I just wanted to comment 1 second. I was the one that got with Representative Schreiber to strike the defacing, and the representative from Garden City is correct. My intent on getting defacing struck from this was so we didn't villainize knuckleheads just spray painting, not even realizing what they're spray painting, just spray painting, when Harry met Sally on a pipeline and not realize it. So that was the original intent of this. Thank you.
Representative Schreiber.
Thank you, Mr. Chairman. If striking vandalizing or vandalize or vandalizing, I mean, if that creates more comfort on this, I think that would be fine. I don't know, since I didn't realize that that's not a really defined term, but.
let's continue on your amendment as is, and then we can have someone, if that's all they're doing.
Do that.
We can.
Okay.
Any further, Representative Carmichael, is your hand back up?
It sounds like we're going to take up some more of this after we work this particular amendment, so I can remain silent.
Perfect. There's no further discussion on Schreiber's amendment. You may close, sir.
Thank you. I close.
For the motion, all in favor say aye. All opposed say no. Motion carries. Representative Hoheisel.
Thank you, Mr. Chair. I do have a conceptual amendment.
Let's hear what it is.
Striking the word vandalize or vandalizing.
Why'd you just come up with that on your own?
Great minds think alike.
Okay, that seems simple enough for a conceptual amendment. Are you okay with that, Natalie?
Mr. Chairman, that is up to you.
No, I get that. I just want to make sure it's not more complicated than Nick just made it sound. Okay, so we have a motion by Representative Hoheisel. Is there a second? Second by Representative Samsel. Discussion? Representative Carmichael.
Mr. Chairman, I'd say this is a good idea, but if I did, it'd probably result in the defeat of the amendment. So it's just a horrible idea. Thank you.
Representative Ralph.
Thank you, Mr. Chair. Just for what it's worth, when we talk about legislative intent and such, back in the old days, if we had to go back, try looking for legislative intent, and we were at the mercy of someone's notes written down someplace. I said, the beauty right now of what we're doing is this will be around forever in YouTube fashion or some fashion. So appreciate the comments of the committee because someone will rely upon that someday.
If I might add, Mr. Chair, there in fact is now a published decision of our Court of Appeals that directly quotes words of yours truly in conference committee that I didn't realize at the time were being preserved for posterity. So be careful what you say here, let alone what you do. Thank you.
Any further discussion? Representative Curtis.
Thank you, Mr. Chairman. And I too have an amendment if Natalie could.
Okay, so let's finish this one.
Oh, I'm sorry.
No,
I thought we were already voted on.
It felt like it. But we
It
haven't.
did.
Okay, so Representative Samsel.
Over my concerns of moving hastily, I think it's better than going tedious right now, so it will have my support. And
Very good. Very good. I'm glad that's the key word of the day. Back to Representative Hoheisel to close.
Thank you, Mr. Chair. I close.
Heard the motion. All in favor say aye. All opposed say no. Motion carries. Representative Curtis.
Thank you, Mr. Chairman. And I too have an amendment. If we could get that distributed, that would be great. And if you want me to go ahead and describe what my amendment does.
That would be Natalie. Are you distributing or starting that process? Okay, so go ahead, Representative Curtis.
Okay, thank you. So what this amendment does is it attempts to address the concerns that were brought forward by the tribes of Kansas. And so this amendment would make it clear, I'll wait till it gets distributed so you can see the language, but it makes it clear that this is in no way to impact or impede on the Native American tribes in Kansas. I'll give it a minute for everybody to get it. Have it. Do you have? You just got it.
Okay, I think we have it. Everyone's had a chance to read it. So Representative Curtis is making the motion to amend. Is there a second? So
My
second by
hand's up.
Representative Sampson. Now, Representative Curtis, if you'd like to describe it, and then we'll see what questions we have.
Sure, absolutely. So the provision, as it reads, it just makes it clear that the section shall not apply to any property containing critical infrastructure facility that is located in whole or in part on any qualified tribal land as defined in KSA. So we heard the concerns of the tribes in Kansas that this bill was targeted towards the Native American community. And so they are very aware and very concerned about this legislation. And my attempt was to make it clear that this in no way was targeted towards our Native American community, and nor will it impede or infringe on any of their rights. As we heard in testimony, this legislation is being offered in other states, and it is in response to Native American action in the Dakotas. And so there's no issue here in Kansas, and so we just want to make it clear that that is not the intent of this legislation. And I think this language helps just clarify that we are in no way trying to impact our Native American communities. So with that, I stand for questions.
Representative Owens.
Thank you, Mr. Chairman. So just out of curiosity, and I want to make sure that I understand the amendment correct. So if it doesn't apply on those lands, so does that hold them immune in the event that they do indeed damage, destroy, or tamper with the critical infrastructure? So as a result, the Native Americans are then immune and actually have the ability to do that without prosecution. Am I understanding that correct?
I guess I might need the help of Natalie to make sure that that's not, that is clear on what that intention is, so.
Sure. Thank you, Mr. Chairman. So the amendment doesn't matter who is doing the conduct. It's about where the critical infrastructure is. So if there is a critical infrastructure facility that is located on any qualified tribal land, then it doesn't matter who you are, either trespassing or maybe, committing criminal damage as defined here. It wouldn't apply. This crime wouldn't apply to you if it's a critical infrastructure facility that is on qualified tribal land.
All right, so just to clarify, Natalie, so if this ran through in whole or on part of tribal land, so if it ran through tribal land, and then some yahoo from Heston decides to go on that land and ultimately destroy it, regardless of their ethnicity, they cannot be held liable under this law. Is that correct?
Mr. Chairman, yes. So if the critical infrastructure facility, if the property that is being trespassed on or allegedly damaged is on a qualified tribal land, then yes, it doesn't matter who you are. The provisions of this section do not apply to that.
Thank you very much. Thank you, Natalie. So from my perspective, my concern is I get the intent of what you're going for, but I'm afraid that it creates a very broad open immunity for somebody to come in and still be able to do this on tribal land. So I'm not sure if there's a better way that it could be written. I have some concerns there, so thank you.
Representative Heiberger, then Carmichael.
Yeah, and I would just like to point out, and Natalie can correct me if I'm incorrect, but almost everything covered by this bill is already made illegal by other statutes that they could be prosecuted under, which is why I don't think the bill is necessary in the first place.
Representative Carmichael, unless Natalie wanted to clarify. Nope. Okay, Representative Carmichael.
Thank you, Mr. Chair. I might also point out that this amendment does not give immunity to Native Americans to go out and violate this law. If they come to Heston if Native American or indigenous people come to Heston to vandalize critical infrastructure, presumably they're going to be prosecuted just like anyone else. But given the history of this legislation, and given the clear testimony of the proponents that their intent here was not to deal with situations related to protests involving indigenous people, it's probably the better part of discretion to respect tribal sovereignty, particularly on tribal ground, and not try to stick Native Americans or indigenous people in the eye and engender a lost support for this bill that might flow therefrom. This is not what the proponents of the bill were trying to prevent, actions on Native land, Native American land. And so we can improve the chances of passage of this bill if we put this amendment on. If we leave this amendment off, then it will be one more argument suggesting that we don't need this legislation at all. Thank you.
Representative Samsel.
Thank you, Mr. Chairman. First, I wanted to recognize the distinguished colleague, neighboring colleague from Lawrence, who also represents Baldwin City. For purposes of discussion, I did second this motion. At the appropriate time, I may consider withdrawing it. I don't support it for the reasons that the previous speaker just mentioned, but we can finish the discussion, but I probably will not support it for the reasons mentioned. Thank you.
Further discussion on the amendment? Not seeing any. Representative Curtis, you may close.
Thank you, Mr. Chairman. And I think, appreciate the discussion. There are already things in place that if there were something that were to happen to any of this critical infrastructure, no matter where it is, there are already things in current law that would address that. So I agree that this bill is really not necessary, but if we are going to move forward on this bill, then I think we need to respect what was brought forward to this committee from our Native American tribes in Kansas, and that we make sure that there is no unintended consequences and that we send a very clear message that this bill was in no way intended to be targeted towards them and the actions that have happened elsewhere regarding critical infrastructure where their voices have just been tried to be silenced. And so I hope that the committee will favorably consider this amendment. Thank you.
Heard the motion. All in favor say aye.
Aye.
Opposed say no. Motion fails. Sure we can. All in favor of the amendment, raise your hand. 4. All opposed, raise your hand. 11. 4 in favor, 11 opposed.
Mr. Chairman, I ask that my vote be recorded on this critical amendment. It's an affirmative vote on the amendment.
Can do that. Representative Carmichael, Representative Heiberger want their affirmative votes recorded. And O'Havison. Representative Samsel.
Yes, Mr. Chairman, I would like my no vote recorded, please, primarily just because I did second the motion. I understand the concerns. I regret that we can't hear from the distinguished colleague given the nature of this we're not taking testimony, but love to hear testimony, proponents, opponents at a later time.
So Representative Samsel's negative vote will be recorded. Further amendments?
Mr. Chairman, was my
yes, Representative O'Havison.
Yeah, was my vote for the affirmative for the amendment?
I think it was, but we'll make sure it is. Kathy, let's get Representative O'Havison down as an affirmative. Representative Humphreys.
Okay.
Thank you.
Thank you, Mr. Chairman.
Is there an opportunity to explain our vote in committee? If not, it's fine. Because I will explain it to my colleagues, but it's fine.
If you want to speak, I mean, there's no written way to do it, but as Representative Ralph pointed out, it's recorded. So if you want a few seconds, go for it.
I just would like to say that I feel like this amendment might just do the opposite of what they're wanting to happen, because as the representative from Heston mentioned, someone could sabotage their land. And if we're concerned about what's happening, then I don't think this bill is helpful. So that is why I had a no vote, because I felt like it could have unintended consequences that would be negative. So if, I know that's not a recording, not recorded, but I did want to explain my vote on that because I'm concerned about that. So thank you.
Representative Keither?
Thank you, Mr. Chairman. I really don't like this bill. I think we don't need it. We asked very specifically for examples showing problems in the state of Kansas and none were brought up. I think still and yet it is putting a muzzle on free speech. And we had testimony that the prison terms were too stiff. And you could say, well, why don't you amend it? Well, I just think we don't need to go forward with this piece of legislation right now. So I will be a no vote for this Senate Bill 172. Thank you, Mr. Chairman.
Representative Heiberger. Sorry.
Thank you, Mr. Chair. I mean, I think my eyes were opened on this bill by the testimony of Representative Long when we heard the bill. I mean, he described how in his district, almost every piece of ground has some sort of, has a oil well or pipeline or some other thing that would be critical infrastructure. And I thought he was going to say, I have to oppose this because this bill would apply to every crime that happens in my district. So that wasn't where he was going, obviously, but I think the thing is just what you brought. I'll bring up the example that I used before. I'm imagining that I've got a quarter section of ground, got a fence around it with no trespassing signs on it. Way in the northwest corner, there's an oil well. It's either hooked up to a pipeline or a storage tank. Down in the southwest corner, it'd be more than half mile away, there's a little pond, and my pal Representative Carmichael wants to jump over the fence and go swimming. He is just trespassed on a critical infrastructure facility under this bill. I mean, it's no longer racketeering now that we've amended it, but I still think it's overly broad. Everything or almost everything that's covered by this bill is already covered by other statutes. I think it's unnecessary, overbroad, and I will oppose it.
Representative Samsel.
Thank you, Mr. Chairman. Hastily comes to mind only from we're moving so quickly on this. We had George Washington trending previously. The distinguished representative from Lawrence might be trending shortly. But I do see for the first time that we have an email her from earlier this afternoon where it says it was first brought to her attention. I see that the distinguished representative from Lawrence is no longer in here. It looked like we had one of her colleagues or acquaintances or something who left somewhat disturbed by my vote. So in all fairness, I would like more time to consider this. So I don't know if I'm allowed to change my vote to present, but if that's allowed or if the committee allowed it, but I honestly don't know whether yes or no. The concerns raised in her email, at least in my mind, warrant more consideration. Given the timing here, I don't know. I'm open to considering this more as we move to the floor, but if it's allowed, I think I would like to change my vote to present.
The vote you asked to be recorded?
Yes, sir. If it could be recorded as present, that's my request. But in any event, I think it needs more attention only because it's a matter of public record. So, Natalie,
how about we just take away your recorded vote of no and perfect? Does that work for you?
That sounds great. Thank
okay,
you,
so
Mr.
Kathy, don't note that Representative Samsel voted against the amendment.
No, it's just all on video of how much.
Right. So people can go back. So Representative Curtis. Anything? We have no motion pending at this point in time. We're all just talking. So Representative Owens to talk a little bit more, and then we'll see where we're going. We'll see if there's a motion concerning the bill.
Yeah, so I guess from my perspective, I don't view this as anything negative towards Native Americans. I think that they absolutely have a right to protest. They have their First Amendment completely intact. What I see this is if we learned nothing over the last 3 weeks about how important our infrastructure is, then we're falling short. When we saw electricity rolling blackouts for the first time in maybe my life, when we saw our cities have to pay exorbitant rates for their gas, and at one point our cities could actually only buy 2/3 of what they needed, by the way. Thankfully, nobody froze to death. Right outside of Heston is a Southern Star gas pipeline yard that has all sorts of wellheads and all sorts of pipe coming out of the ground. I could only imagine if in the heat of that, somebody wanted to be a vindictive yahoo from Heston and set that sucker on fire or blow it up or or do some significant damage that stopped the flow of gas when it was 10 below. I mean, think about the implications of what that would have had for my community and for other communities. And so an enhanced penalty in that situation, I believe absolutely is applicable. When we think about how dependent we are as a society on our electricity, on our gas, on our water, I mean, you think about those critical pieces, I think an enhanced penalty is absolutely relevant. And I wish there was a perfect way to say the Native Americans can still protest, but in my mind, that's still protected under the First Amendment. I guess from my perspective, I want them to have that ability. I want everybody to have the ability to protest and to speak their mind. But I think the importance of protecting our infrastructure on this level is a very, very important piece. So thank you.
Here's where we are. Representative Carmichael has had his hand up for a while, so I'm going to call on him, and then we're going to see if there's a motion concerning the bill, and then we'll keep talking. So Representative Carmichael, if you wanted to explain your vote on that last amendment or anything else at this point in time, or do you want me to see if we can get a motion, and then you can talk?
Well, Mr. Chairman, I was actually trying to figure out whether we were on the bill or whether the chair is still entertaining amendments to the bill. But I think my colleagues are arguing the bill. Well, just so it's simple, I did ask the reviser to draw an amendment regarding critical medical infrastructure, which I've shared with some folks. But in view of the fact we have 5 bills above the line tomorrow from this committee, it's 5:30. I just asked that the reviser draw that for the floor, and we'll take the matter up if and when this bad legislation reaches the floor. And once we have a motion on the bill, then I'd like to be recognized.
You got it. So committee, Representative Hoheisel. 172.
Thank you, Mr. Chair. I move that we pass out SB 172 favorably.
Is there a second? Representative Samsel. Discussion. Back to Representative Carmichael.
Thank you, Mr. Chair. Even though the hour is late and we have 5 bills above the line, it's important for this committee to realize what we are doing here today. We are not saving any pipeline facilities outside of Heston, Kansas. We have arson statutes. We have a panoply of statutes. We have federal laws. We have all sorts of things to protect those facilities outside of Heston, the facilities in South Hutch, the facilities near McPherson, and everywhere else. This is about something very different. This is about the American Legislative Exchange Council's scorecard. When you heard Mr. Kreidler, the principal proponent of this bill, talk about, well, I just took a page or two of a suggested bill into the reviser's office and then look at what they prepared in response, we all know where it came from. This is ALEC. And it doesn't have anything to do with protecting critical infrastructure. We have all kinds of laws to protect critical infrastructure. People are in the federal penitentiary for a long, long time for blowing up pipelines and those sorts of things. No. This bill is because ALEC wants to put it to Native Americans. That's what it's about. I'm not going to call it racist legislation because somebody might file some charge against me. But that's exactly what this bill is about. It's about punishing the Native Americans who tried to stop the construction of the Keystone Pipeline. That's what it's about. And if you want to be associated with bills that have that type of motivation, then here's the one for you, but not for me, Mr. Chairman. Thank you.
Representative Curtis? Very good. No worries. Anyone else to speak on the motion? Seeing none, Representative Hoheisel, you may close.
Thank you, Mr. Chair. I close.
For the motion, all in favor say aye. All opposed say no.
No.
Motion carries. The affirmative votes wanting to be recorded are Owens, Hoheisel. The negative votes wanting to be recorded are Heiberger, Carmichael, O'Hobson.
Oh,
Committee,
maybe
that's it
Keither
for
this
today.
time.
And Representative Keither as a negative vote as well. Committee, that's it for today. So bills for tomorrow. Let's see, we still have 283, HCR 5014, 122 from today. And then if 2412, which is the opioid litigation bill that we heard yesterday, I know some of the parties are working on a balloon. We'll see if they get there, but let's put that on the list as a possible bill tomorrow. I'm also going to put Senate Bill 273 on the list of bills that we could work tomorrow. That's the Senate KEMA bill. I have no intention of working the Senate KEMA bill, but we're having a hearing tomorrow, which is yet to go out because it's got some, for whatever reason, the system hasn't updated to allow it to go out. But I know Kathy sent out an email to the distribution list. Look at it tonight. It's House Bill 2447. It deals with the Security Act fee fund. It's a bill as a result of some litigation that's going on that we may need to try to make sure to get out of here before the end of the week. So we may use that Senate shell. So we will hear that tomorrow. Oh, actually, Kathy just tells me revised 2 is out. So I guess you have gotten it. So we'll have that tomorrow. There is a chance we will have another bill Thursday. It's another litigation related bill, and I'm trying to find out for sure if we need to do something this week or not. As I know more, I'll keep you posted. I did just put the topic in general is on the agenda as a potential informational hearing, but we'll see what happens tonight and tomorrow, and I'll keep you all posted. But that's where we're at. So I appreciate everyone's attention and good work today and good dialogue, and we will see you all tomorrow. Thank you.